Thank you for your patience while we got things turned over. We have two more cases to be argued this morning. The first case is Ungenbuehler, I hope I'm pronouncing that correctly, versus Kelly. If the council could please state their name and their readiness to proceed.
Sure, Your Honor. My name is Jason Starling. I'm the law firm of Willis Stangle Starling on behalf of the plaintiff appellant, Kayla Ungerbuehler.
Ungerbuehler. Okay, got it. Thank you.
And good morning to the court. George Muskamp, Taft, Titius, and Hollister on behalf of the appellees, James and Kristen Kelly.
Okay, thank you very much.
And my co-counsel is Trevor Nichols.
Okay, thank you. Okay, and then the last case to be argued today is State of Ohio versus Faith Dunn.
Good morning, Your Honors. Morgan Gall on behalf of victim appellants PH and WC.
Okay, thank you.
Terry Gustafson on behalf of the appellee Faith Dunn, ready to proceed, Your Honor.
Okay, thank you. If you would like to go ahead and get started, you may. Would you like to reserve any time?
I would, Your Honor. 5 minutes for rebuttal, if that's all right.
Yep, that is fine. Whenever you're ready.
Thank you, Your Honors. May it please the court. I may look young, but I think I've been old enough that I remember when notice pleading really meant notice pleading. 20 years ago when I was in law school, my civil procedure professor told me that motions to dismiss are very limited. They're really only used in two situations. Number one, when the complaint was so unintelligible, the defendants had no fair notice of what was actually being alleged against them. And then number two, when the defendants did know the causes of action that were being alleged against them, but they weren't recognized by the law. And I think we've lost a little bit of that, especially post-Twombly and Iqbal, as those concepts have leaked into state court, where fortunately, at least for plaintiffs, we still operate under the rules of notice pleading. When you look at those two concepts, fair notice and is the cause of action recognized, and you go through the counts here that were in the complaint, it seems readily apparent that given the liberal rules of pleading, the liberal rules on amending pleadings to clean up any mistakes or errors or omissions, that the motion to dismiss here, specifically under Rule 12C, should have been denied. I'd like to, I think, start with count one. It's probably the easiest in my estimation. We agree with the trial court that our cause of action was recognized. The Ohio Supreme Court recognized public policy claims under 4112 for employers with fewer than 4 employees under Collins v. Rizcana. And then since then, we've cited a bunch of cases in our brief where that was extended to disability discrimination claims, like the ones we alleged in this case. The whole issue here, at least from the trial court's perspective, was that we didn't allege a simple sentence. The defendants employed fewer than 4 employees. And the whole issue then is, could we have alleged that? Well, it was undisputed. Absolutely, we could have alleged it. And in order to cover myself as a plaintiff's attorney, in case any type of argument like that ever comes up, I specifically argued in our briefing on the motion to dismiss, hey, if I missed a fact that you think is of consequence, tell me so I can amend and add it in. And we asked for that here. And for some reason, the trial court never really explained it, I suppose, but for some reason the trial court said it was futile for us to allege defendants employed fewer than 4 employees. Well, they're 2 individuals. They asserted in their defense that they weren't an employer with 4 or more employees. It was undisputed that they had fewer than 4 employees. Why couldn't I allege that? That makes absolutely no sense to me. Why would you dismiss a claim on that basis? So we think in terms of count one, the other frustrating part, and we put this in our brief, was that nobody even really argued that, right? So down below in the briefing, if you go through it on the motion to dismiss, the defense never argued, well, he didn't allege we had fewer than 4 employees, so he should lose. Well, if they had done that, particularly if it was, say, a 12B6 and I could still amend as of right without seeking leave, we would have just fixed it. End of story. And even so that it was on a 12C motion that came a little bit later, I still asked for leave to amend if there was a missing fact, and the trial court denied it to me. Without the defense even arguing that, I had to find out for the first time that we had missed a fact, supposedly, when the trial court issued its decision. I don't know how frustrating that is, or how much I can express that frustration in this court. That was an argument we didn't even have an opportunity to respond to. So I think if you look at it in those terms, count one pretty straightforward. It really just hinges on, could we have alleged fewer than 4 employees? Well, absolutely. Everybody understood that. These are two individuals, suburban couple who employed a nanny. Straightforward. Everyone assumed it. Looking at counts 2 and 3, I think that is straightforward as well. For some reason, I don't know why, the trial court never discussed Onderco v. Sierra Lobo. Now, that was the Ohio Supreme Court case that held we don't have to allege a compensable injury under the workers' compensation statutes to have a workers' compensation retaliation case. It aligns the 412390 claim with every other retaliation claim that exists out there under federal law, state law as well. The idea that you just have to engage in protected activity by having a potential workers' comp claim. You just can't have a fraudulent one in this case, is what the Ohio Supreme Court said.
Just so I am clear about the record, was there notice provided that your client planned on filing a workers' comp claim? And if so, what is the timing of that?
So the timing is a little unclear. As we alleged in the complaint, she had a conversation with them where they threatened her if she filed a workers' comp workers' comp claim.
And that was before she was terminated?
That was before she was terminated. Actually, I don't remember off the top of my head, but I believe it was before she was terminated. It might have been after, so don't hold me to that. I don't have the complaint in front of me, I apologize.
Okay.
But regardless, what it shows, at the very least, if you're looking at it and construing the facts in light most favorable to the plaintiff, as you must on a motion to dismiss, what it does show is that the defendants were worried that she might file a claim. And that puts them either in the 412390 statutory claim, because there was some conversation about whether they're going to pay for her medical bills, which can be protected activity for a 412390 claim, or alternatively, it might put her in the public policy version of that claim, which is that before she could take steps towards filing the claim, the employer wanted to get rid of her. So it might be in that gap filler. The point we made in alleging them the alternative is that you need discovery. You need to take the depositions of the defendants, find out when they decided to take action, what the factual timeline is, as Your Honor's talking about, to decide which claim applies. So either way, she's going to be covered in that regard because she claims that she suffered a workplace injury. It doesn't matter that it's not compensable under the coming and going rule.
What was the adverse employment action that she suffered as a result of the workers' comp claim?
There's really two, but we're only going after one because it's the one that matters the most. The first was reducing her hours. So as we put in the complaint, after she suffered the car wreck, incurred these disabilities, needed surgeries, she asked for an accommodation request. And that accommodation request was reduced hours or not having to travel. It was not having to travel. And then in response, they reduced her hours, which can be an adverse action because it affects her compensation.
So does the clock start ticking from the reduction of hours?
No, only if you're suing on that. So the clock starts ticking from when she was notified of her termination, which is the adverse action on which we're suing. So after they reduced her hours, they then changed their mind, reversed course, and went and terminated her. And that is the adverse action on which we're suing. So the clock starts ticking from that on that adverse action. If we wanted to sue on the reduction of hours, then the clock would start ticking for that.
But you're suing on retaliation.
That's correct.
And the retaliation, she was first on notice of the retaliation when the hours were reduced.
But only as to the hours, because she hadn't been fired yet, right?
Right, but the hours were an adverse employment action.
Right, but we're not suing on that. If you look at
I understand that, but
Okay.
in terms of the retaliation claim, it was completed when when she made it clear she was going to pursue a workers' compensation claim and there was some adverse action as a result. That created a workers' compensation retaliation claim, is that right?
It did, yes.
Okay, and why wouldn't the clock on that claim start ticking at that point?
So it depends on the adverse action, right? So as I identify it, there's two. There's the reduction hours that you're talking about, and then there's the subsequent termination. So if we had, say, count one, retaliation, reduction hours, that would run from when her hours were reduced, as you're talking about, Your Honor. And if then we'd add count two, retaliation, termination, as we do in the complaint, that starts running from the termination. It would be unfair to impose a statute of limitations or a time clock on an adverse action that hasn't happened yet, simply because an adverse action, another one happened before it. Does that make sense?
I understand what you're saying. I just am concerned that, in my mind at least, the retaliation claim came into existence when they took the first adverse action.
Sure, as to that adverse action, I absolutely agree. But if there's a subsequent adverse action, we can't start the clock ticking on it when it hasn't happened yet. That wouldn't be fair. That's my view on it.
Okay, I understand your argument. Thank you.
You have about a minute left if you want to reserve 5 minutes.
Okay, I'll just go through very briefly on counts 2 and 3. I don't know why the trial court didn't look at Onderico v. Sierra Lobo and the compensable injury rule. We addressed it at length. The trial court didn't even address it. We also want to draw the court's attention to Wilson v. Riverside Hospital. We don't have to plead extensive facts for a 412390 claim or its public policy equivalent. I just asked the court, when you're looking at what constitutes fair notice of a complaint, there's these form complaints in the back of the Ohio Rules of Civil Procedure. Federal rules used to have them, but then they got Twombly and Iqbal and they got rid of them, okay? The form complaints are so simple. Like for motor vehicle collision, it literally just says the defendant negligently ran into the plaintiff, all right? Did we put enough in here in this complaint for the defendants to know what they were being sued for? Absolutely. Are those causes of action recognized? Sure. If there's some mistake that I made by not saying the magic words, let me amend and fix it. Thank you.
Thank you.
If I just stop.
Oh, that's fine.
Good morning, Your Honors. We're here today on a case that really never should have been filed. We're here today on a case against the parents of small children filed by their nanny on claims that have been specifically barred by the Ohio General Assembly. The General Assembly has spoken clearly, unambiguously, that all 3 claims brought by Ms. Ungerbuehler are barred as a matter of public policy that actually benefits the Kellys as the parents of the children, not Ms. Ungerbuehler. And they did that for good reason, right? If we think about count 1 and we think about a parent separating from childcare with their nanny, right? What the legislature has said is that the parent is in the best decision to decide why they may hire a nanny, why they may separate from a nanny, who they want in their private homes, who they want caring for their children behind closed doors, unattended, for hours at a time, bathing their children, clothing their children, swimming with their
And
children.
the parents do that for illegal reasons?
By illegal reasons, do you mean under
Like
4112?
retaliation, for example?
I think 4112, the legislature has spoken that the reason does not matter for purposes of a household employee like a nanny. And when Mr. Strawling was given his opening here, he did not mention whatsoever the carve-out for domestic workers.
So parents could fire a nanny or could refuse to hire a nanny based on, for example, race?
Yes, that is what the statute says. That is why there is a specific carve-out for domestic workers. If the courts want, or if the statute wanted to that include race, they could have just said anybody. They've made a specific exception based on a parent's fundamental right to choose childcare for their own children to include an exception for domestic workers. That parents should not be hauled into court, questioned.
So a parent can threaten a domestic worker who's injured in their home in the course of their employment if they file a workers' compensation claim. Is that your assessment of the law?
Well, I would say it depends, if we're talking about the workers' comp retaliation claim.
Correct.
So the difference in that example is the timing. It's all about the timing under Sutton v. Tomco and the statutory language. The statute says for a workers' compensation retaliation claim, you have to have either initiated, pursued, or filed a claim. That is how you engage in protected activity. If you don't do either of those 3 things, you're not entitled to protection. It's like saying, well, I was going to blow the whistle, but I never did, but I still want whistleblower retaliation. Under the whistleblower retaliation statutes, the way you get protection is you have to blow the whistle, and it's the same thing here. Now, Your Honor, there is one exception to that rule, and it's under the Tomco case, and what the Ohio Supreme Court said in that case is we're not going to create a foot race. So if you didn't pursue a workers' compensation claim, but you were going to, and in Tomco it was literally hours, the employee was injured and the employee was injured or fired the same day, we're not going to create a foot race to who can file a workers' comp claim before you get terminated. Here, Ms. Ungerbuehler had 8 months she was injured in a car accident and then terminated 8 months later. On her own pleading, that's what she says. She had more than ample time to file a workers' compensation claim and seek the protection under the statute that she wants in this case.
Does the statute define initiate?
I think it's filing a workers' comp claim.
Well, I appreciate what you think, but does it also include notifying the employer that you intend to file a workers' compensation claim?
That is not how the statute defines initiating. a
And so
claim.
that action, in your argument, is not protected? To announce to the employer, I'm filing a workers' compensation claim, and then be fired, your assessment is that's not protected?
Depending on the timing, right? If the injury happened that day and the employee went to the employer that day or even a week later and said, I intend to file a workers' comp claim, and then they fire him, I would say yes.
So how much time can pass?
I think it's a reasonableness analysis. I would certainly say 8 months is too much. And if you want to get the protection of the statute, that's why the statute is there. That's why nothing is jeopardized in this case. No public policy is jeopardized because has she availed herself of the statute, if what she claims is true, she would have had the protection under the statute. That's why the statute is there. She could have sought protection in the statute, but she didn't.
Does she have to file a viable workers' compensation claim or just file a claim?
I think she has to file a claim, and I do agree that if there's a factual dispute on whether the claim is viable, I agree at the pleading stage, she does not need to plead and there doesn't need to be a factual inquiry at the pleading stage.
No, ultimately,
Right.
if the workers' compensation claim is denied or deemed not viable otherwise, does that then eliminate the retaliation claim?
I would say no. I would say, though, she would have to have a good faith basis for workers' compensation claim, and for two reasons, Your Honors, we know she did not.
Well, and because we want to protect individuals' abilities to assert a workers' compensation claim.
Correct.
Not only filing the claim, right,
Agreed.
but also notifying the employer that you intend to pursue a workers' compensation claim.
Correct. But what we don't want to do, though, is to allow for bad faith workers' compensation claims.
But that's not protected under retaliation claim.
A bad faith claim? No, certainly not. I don't think it's the public policy of the state of Ohio to protect people who pursue bad faith worker compensation claims. And we know for two reasons why it would have been in bad faith. One, she sued the driver that hit her in the car accident. And the court can take judicial notice of that case. It's A2302846. She sued the driver that hit her.
What difference does that make? If it was in the course of and arising out of her employment,
Because under the workers' compensation statute, that's your exclusive remedy. If you claim you are injured in the course of your employment, you can't sue the driver and then also go seek workers' compensation benefits. Once you elect your remedy to sue the driver, you are telling the world, I was not injured in the course of my employment. If you were injured in the course of your employment, you have to go the workers' compensation route. That's it. That's your
doesn't that just give the Bureau subrogation claim against the driver?
what also elects her sole remedy. You can't do both. You can't seek workers' compensation benefits and sue the driver for the same injury. It's either in your employment or it's not. If it's in your employment, your workers' compensation. If it's outside your employment, you sue the driver. She sued the driver before the Kellys terminated her.
Well, is it that you can't sue or you can't collect double damages?
I mean, I guess I would say it's a fraudulent workers' compensation claim if you do it that way. I guess she technically could file the paperwork, but if she sued the driver acknowledging it was outside of her employment, and then turned around and sought workers' compensation benefits for the same injury, I would say that's a fraudulent workers' compensation claim. And again, we're going back to if she didn't, the coulda, shoulda, woulda, right? The Kellys can't retaliate against Ms. Ungerbuehler for something she never did and something she never could have done. I mean, technically, she could have filed for workers' compensation, but it would have been fraudulent. It would have been in bad faith. For two reasons, the coming and going rule, which the court found, and two, she elected a remedy by suing the driver. Does that answer your question, Your Honor?
It does, thank you.
Okay. So I think we've covered the workers' comp piece. Coming back to the retaliation statute, but it's kind of in the same vein, right? The statute is intentional that it only applies to employers with 4 or more employees. And the Ohio Supreme Court has actually, since the Collins case, never expanded Collins beyond sexual harassment or sexual discrimination. And if you read the Collins case, the way that court, the holding actually says it is limited strictly to sexual harassment and sexual discrimination claims. And it relies on a criminal statute outside of 4112.02a in making that finding. At no point since Collins in the 30 years has Collins ever been expanded by the Ohio Supreme Court to include any other claim other than sexual harassment or sexual discrimination. It has never been expanded to disability. And actually, the Ohio General Assembly in 2 different Senate bills has proposed to bring amendments to 4112 that would have included childcare, nannies, domestic servants. And in both situations, the Senate bill did not pass. And ironically, in both those proposed Senate bills, which we referenced in our brief, disability discrimination was carved out. And again, as a matter of public policy, we don't want parents to be in a position, do I need to accommodate my nanny for this disability? Should I hire them? Do I want to separate from them? Because I might get sued if I don't. Or is it in the best interest of my children to make sure I have a nanny who is fit for the position I choose based on whatever criteria I want? So I understand kind of the hypotheticals that we've all talked about, but really what we're talking about here is disability discrimination. That's the narrow avenue that Ms. Ungerbuehler is trying to go down. No Ohio State court case has ever expanded Collins to include disability discrimination for a domestic servant, ever. There's no case ever saying that. And there's no case outside of 2 federal court cases cited by Ms. Ungerbuehler where disability discrimination was allowed for an employer of fewer than 4 employees outside the domestic service context. Both of those federal court cases have never been cited by any Ohio State court case for the proposition in those cases. And certainly the Ohio Supreme Court has not expanded Collins. So I would say Collins is still good law in strictly the narrow holding for sexual harassment, which relies on a criminal case, which is why we haven't seen any expansion in the 30 years since Collins was held. So for 2 reasons, Ms. Ungerbuehler's claims fail. She can't meet the definition of employers by the Kellys, but more fundamentally, if we really take like a big step back what this case is about, the General Assembly included domestic servants for a reason. If we include a public policy for a carve-out of domestic servants, we've completely gutted the entire statute. And I think it's the goal here to apply the legislative intent as it's written. And actually, if you read the Miracle case, which is the Ohio Supreme Court case after Collins, that's exactly what happens in the Miracle case. There's an employee who's working as a civil servant, fired under reasons that he disagreed with, but he didn't meet the test to be a tenured civil servant. And the Miracle court said, actually wrote it down, the exact quote, that applied directly here. The General Assembly has spoken clearly. Probationary employees do not enjoy the same rights and protections afforded to tenured civil servants. Accepting Miracle's argument would contradict this legislative design by treating probationary civil employees the same, if not better than tenured civil service employees. That's exactly what we have going here. The General Assembly has made a decision, an intentional legislative design, where domestic employees are treated differently than regular employees, especially those that work for 4 or more, an employer with 4 or more employees. That Miracle case was an Ohio Supreme Court case decided after Collins. And even since then, we look at the FMLA context, where you have employees who don't work for 12 months and therefore don't qualify for FMLA protection. It's certainly a public policy, a good public policy, not to terminate employees when they're taking leave to care for a serious medical condition. But Ohio courts have consistently said, if you have not worked for 12 months, you are not eligible for FMLA leave. Therefore, you cannot circumvent the statute by bringing a wrongful termination claim. If you don't meet the eligibility requirements of the
Hold on.
statute, you
I'm
don't have a
sorry.
public policy claim.
You're saying under Ohio law, a disabled employee can't sue for wrongful termination if they've been employed for less than 12 months?
I'm saying under the FMLA.
Right, but they have discrimination claims that they could bring.
They might have separate ones, correct. But
Yeah.
the Ohio courts have specifically said you can't circumvent the legislative design of the FMLA by bringing a public policy claim if you want to be employed there for 6 months. And we see that under the ADA. We see that for independent contractors. Independent contractors can't circumvent the statute by bringing wrongful termination claims. Interns can't do it. Volunteers can't do it. You have to be an employee. Meeting the eligibility requirements of the statute forms an essential function of the public policy.
Let me turn quickly to the argument about the trial court's basis for the dismissal being that they didn't allege that there were fewer than 4 employers. Is your position that that was a correct holding?
I don't think that's what the trial court held. If you actually read, it's not crystal clear in the court's decision, but I agree with Mr. Starling. We all agreed, we briefed it as well, that was our main argument. One of our main arguments is we don't have 4 employees. So I don't think the trial court would have gone out of their way and done that. Plus, when you look at the in the court's order, it talks about whether Ms. Ungerbuehler would have an opportunity to amend, and it says you can't fix this by amendment. I mean, I think the trial court would have realized if all you needed was language saying we employ less than 4 employees, it would have said, all right, go ahead and amend and do that.
And that would have been the proper response to that.
If that's what the trial court actually found, right, I agree. But I don't think, because the trial court didn't do that, I don't think that's what the trial court's holding actually was. I think the trial court was saying they don't employ 4 employees, or more than 4 employees. You can't gut the legislative intent and design of the statute. Therefore, you don't have a public policy claim. You can't circumvent the statute by bringing a public policy claim, is what the trial court held. But on de novo review, which this court can do, it could affirm on that basis, or affirm on the basis that she's a domestic servant and does not qualify for protection either under that basis as well. I think there's 2 ways that the 4112 public policy claim fails.
What protections are provided then for domestic?
At this point in the state of Ohio, it's Collins v. Rozanka for sexual harassment and based on criminal statutes.
And short of that, parents can do what they want.
Yeah, it's up to the General Assembly. If the Ohio General Assembly wants to pass a statute and fix that gap for domestic servants, which they've tried to do twice, they can do that. But they've decided not to. And 4112 has actually been amended, I think, twice since Collins, and in both times they've left it in. I don't think it's the job of the courts to change what the legislator has intentionally put into the statute. And you see it in New York. We cited a case in our brief. New York actually did pass a statute for domestic servants that said you get protections. Again, ironically, and importantly, even under the New York statute, there was a carve-out for disability discrimination. It did not include protection for disability discrimination to domestic servants. Not that New York matters, but
Unless there are any more questions from the panel, your time is up.
I'm sorry, I apologize.
No. Did you have any
No.
more questions? Okay. Thank you. Mr. Starling, you have exactly 5 minutes.
Thank you, Your Honor. Look, I've got my issues with the General Assembly, but even I don't think they're bigots who say you can discriminate against your nannies however you want. The issue with that is the domestic servant exception comes in the definition of employee. That definition of employee is only used for covered purposes. It's only used to determine whether the employer is covered by the statute. So they have to have 4 or more employees. The statute actually protects against discrimination any persons. And noticeably absent from the definition of person is the domestic servant exclusion, which is precisely what we argue in our brief. When you take those 2 definitions and juxtapose them and how they're used in the statute, along with the fact that, as the Ohio Supreme Court has held many times, the statute is is a remedial statute that has to be construed liberally in favor of employees. I think there's no question the General Assembly wanted to protect domestic servants. They just didn't want them used for purposes of counting the number of employees. That's it. As far as the Miracle case, I don't know why my colleague is even citing it. I wrote the amicus brief on that case for the Ohio Association for Justice. It literally had nothing to do with the case, the issues in this case. It was a public policy claim about one of the statutes on probationary employees under civil service. Nothing to do with 4112. Looking at the reasonable amount of time to file a claim, I don't know where that comes from. In a workers' comp claim, like the workers' comp statute, my colleague talks about the reasonable amount of time, and 8 months is too long. Well, the statute of limitations on filing a comp claim is 1 year. Why would 8 months be too long? You would think it'd at least be after the statute of limitations, and the statute of limitations used to be 2 years. Why would it be that they can have up to a year to file a claim, but if they file it past 8 months, that's too long and they're not protected? There's literally nothing in the case law from which that principle comes that my colleague is arguing. I don't even know where it is in the case law. As far as good faith basis, I don't know how you could determine that on a 12B6 or a 12C motion, right? That may be an affirmative defense they could make or argue later on, but that requires a factual finding, right? That requires evidence. It requires deposition testimony, credibility determinations. You can't decide that on a 12B6 or a 12C. Certainly, we didn't allege that she lacked good faith when she attempted to pursue a workers' comp claim. She was threatened about it. So I don't know where that comes from either. Looking at the case law, my colleague used some very clear language. He said, no Ohio state court cases expanded Collins v. Rizcana beyond sexual harassment or sex discrimination. Well, Ohio federal trial courts have, and they found that the rationale in Collins applies equally to any other type of discrimination. Like if you look at Ohio Revised Code 4112.02a, where it has the prohibition against discrimination, disability is right next to sex, which is right next to race, which is right next to national origin, why would we distinguish between any of those when they're literally in the same exact sentence in the statute saying you shall not discriminate on these bases? I don't see a reason to distinguish Collins on that basis. I think that is an overly restrictive argument, as did those Ohio federal court judges who agreed and said you can bring disability claims under Collins v. Riscana. Long story short, I mean, these are valid claims. There's no question. Nannies have protections. There's no nanny exception for 412390 or its public policy. And the nanny exception when it comes to 4112 is literally counting employees, and that's it. I can't tell if my time is up.
It is not. You have another minute. I just forgot to change it from stop to go.
Oh, you're perfectly fine, Your Honor. So I think there's really no question on the 412390. There's no nanny exception. She got threatened over a claim, which implies that they thought she was going to file one, which tells you that all you need to know in terms of the protected activity and whether there might be retaliation there. That's certainly fair notice and a good faith basis for the claim to proceed to discovery. As far as the 4112, we've gone over that. The long story short is we should have been able to plead those facts. I appreciate what my colleague was trying to do in terms of, I hate to say put a spin on it because I'm not trying to make it a pejorative, but in terms of how he was trying to describe the trial court opinion, the trial court actually agreed with us that the statute does cover nannies, the public policy does cover nannies. I think if you read the opinion, that's what it says. The trial court instead just found a way to kick us on the factual allegations, which is incredibly frustrating. I don't know why the trial court did that, but it did agree with us on the law. And I think the law is very straightforward in the statute. When you read it, when you interpret it liberally in favor of employees, given its remedial statute, nannies are in fact covered. They have every right to pursue their profession free from discrimination like any other Ohioan. Thank you.
Thank you. This case has now been submitted, and we will issue a timely decision. The last case to be argued this morning is State of Ohio versus Faith Dunn. Whenever you're ready, come up to the podium. Would you like to reserve any time?
Yes, Your Honor, 4 minutes, please.
Okay. Whenever you're ready.
Good morning, Your Honors, and may it please the court. My name is Morgan Gall, and I represent victim appellants PH and WC. Your Honors, in this matter, victim appellants did everything they were legally required to do to assert their right to restitution at the trial court level. They requested restitution both through the state via documentary evidence and a victim impact statement submitted through the probation department in a pre-sentence investigation report, and yet they were awarded nothing. To this day, they have yet to recover a single cent of reimbursement for the total loss of their vehicle that was never recovered.
What evidence did they submit to support the value of the lost vehicle?
I believe it was a picture and a Kelley Blue Book estimate for the private party value is what they were asking for, but it had the range from fair market value to private party value.
And did they submit evidence of the miles on the car?
Your Honor, my understanding, and I have not actually seen the victim impact statement because it's part of the pre-sentence investigation report, which is not a public record, so that wasn't provided to me. But my understanding based on the city's brief is that it was up in the website. It said 65,000 miles in the website. But to be clear, nobody rebutted the evidence that was submitted at the trial court level. Alternatively, the defendant, both herself and through counsel, acknowledged that they were asking for $6,175 and expressed want to pay that. Her defense counsel specifically on the record states, I guess I could ask for a restitution hearing, but my client is more interested in being released and paying the restitution. So therefore, I don't think that there can be any question or dispute about what was presented. I think if the amount is agreed upon per the statute, the restitution statute, then that's the amount. There is no discretion for the trial court unless there is that restitution hearing. Then I think at that point, we would be here under a very, very different review. But right now, it's a de novo review. There was no discretion, there was no dispute about the amount of restitution that was requested. And per the Constitution, they have the constitutional right to full and timely restitution. If that amount was agreed to by the parties and the victim, and there was no dispute, then that's the amount that should have been issued by the trial court.
Well, was it agreed to, or was the defense simply foregoing their right to a restitution hearing? Usually it's the defendant that's asking for a restitution hearing. It seems like here the victim is asking for, are you asking for a remand for a hearing, or do you just want the amount?
I think that this court, under a de novo review, can issue the amount that was asked for at $6,175 because the defendant waived any dispute or and their right to a restitution hearing. And the victim is certainly not disputing the amount that they requested. So without that dispute, I don't know that this court has to remand for a restitution hearing, but I think even if you did, it would have to be under the de novo review, not an abuse of discretion review, because the trial court never got to an analysis of the evidence that was presented for an amount of restitution. Rather, the entry by the judge specifically blanket.
At that point, was it even evidence? It wasn't like they were stipulating. It wasn't, they were just saying, we don't want to have a hearing. The defendant was saying, we don't want to have a hearing because they were willing to just forego a hearing.
Right.
So it's not a stipulation as to the amount, and certainly it's not evidence, it's simply a sentencing hearing.
Mm-hmm.
So wouldn't the appropriate thing to be done would be an actual hearing, so both sides could dispute whatever the evidence was?
I think this court could determine that. That's not what the victim appellants are requesting here. What they're requesting is that that you issue an order saying that the trial court failed to acknowledge and uphold their right to restitution. And then if it goes back down to sentencing and the defendant wants to dispute the amount at that point, then I guess they do get a second try at that in this situation, because we're here and it has to go back down in order for there to be any talk about restitution. But I think procedurally where the issue was in this case and where it should have ended was that the trial court should have acknowledged that both parties agreed to that amount of restitution and issued an order for $6,175 to the victims for that restitution, because the way the statute is written, it says the trial court shall award restitution, and then it has the permissible if there is a dispute, then the next step would be a restitution hearing. But there was no dispute on the record or otherwise by the defendant. For the first time ever, the defendant appellee argues on here that the record was void of competent, credible evidence, but that's a disingenuous argument based on the fact that they did not bring that up at the trial court level. So I don't even know that this court can properly have any analyzation of that argument because the trial court didn't analyze that argument. And I think that would be under an abuse of discretion standard that we're not here under today because there was no discretion for the trial court at this point. Significantly, the defendant herself acknowledges, I can pay this amount, I want to pay this amount, I want to take responsibility. So again, I think that is a blanket waiver of any dispute on the amount of restitution or that evidence that was submitted. And I know, Your Honor, you corrected me and said it's not evidence. It's not. It was submitted with their victim impact statement, but they didn't question it, and I understand that the evidence rules don't really apply at a sentencing hearing, but again, at that restitution hearing, there could have been documentary or testimonial evidence presented, but the defendant waived their right to that.
What, if any, impact does the money she got from her sister have on the restitution claim?
The defendant getting
Yes.
money from,
No, I'm sorry, the victim. I understand she had hoped to repay her sister who had loaned her some money for a new car. Is that correct?
Your Honor, again, I have not seen the victim impact statement because it's part of a pre-sentence investigation report that I have not provided. So if that is the case, I still don't think that that matters because her name is on the title, so the loss was hers.
So, RC 2929-281A says that any restitution award shall be reduced by payments to the victim for economic loss made or due under a policy of insurance or governmental program. So, how do you respond to that? Why wouldn't that apply here?
So they didn't have insurance on the vehicle. I think that was a misunderstanding at the trial court level, and
Is
wasn't.
there evidence of that?
I don't believe anybody asked for evidence of it because they agreed to the amount, so there was no dispute on whether they had insurance or not. My understanding is they do not have insurance, but even if they did, this court has held that they're not required to file an insurance claim.
Are you talking about in Haskett?
Yes.
Okay, the difference between that case and this case, nobody cited that statute in Haskett. And so it wasn't an issue because nobody cited it. Here, it is an issue. So can you explain how that would not apply?
Well, because they don't have insurance, so they wouldn't be able to file
But again,
an insurance claim on this. And if I think the intent of the statute there is that you can't double dip. So they can't go get $6,175 from insurance and then come back and ask for that in restitution. In that situation, which we see often, if a victim does pursue an insurance claim, usually the amount they're requesting for restitution would be their deductible, which may be $500, which may be $1,000. And so I think the intent of that statute is to say, hey, you can't go recover all of this money and then recover more money. It's about making the victim whole. It's not about making sure the victim profits. And that's not what the victims are asking for here. They're simply asking for the amount that they have as an out-of-pocket expense based on the fact that this car was never recovered and couldn't be repaired.
And that same logic holds true to the extent she did get money from her sister. If she got $6,000 from her sister, she would then not be entitled to an additional $6,000 under the restitution statute.
So I think the out-of-pocket loss comes, I guess that would have to be disputed in a restitution hearing, Your Honor. I think whether or not that money, where that money came from, again, her name's on the title. So I think it is her loss.
Does
And
it
the fact
matter,
that-
does it matter if, well, the statute's very clear that if any, it's clear in general if it came from insurance or an agency that it's reduced. But from a third party though, does it matter if it's a loan or if it's a gift?
No, Your Honor, I don't believe so, because if it's her car, and let's say it was insured, and she makes the insurance claim, that money is coming to her unless she has a lien from a car dealership, then that money goes to them, and any other money would go to her in excess of that loan amount. If it's a gift, if my parents give me a car, it's mine,
No,
and
no,
it has
I-
my
Okay. So what you're saying then, if I'm understanding you right, is that the money from your client's sister, what you're saying is that was not to compensate her for the loss, that was to buy this new car. Is that your argument?
Yes, Your Honor.
Okay.
So but she's not asking for, so there's case law, and I think my colleague cites it, that this court specifically found issue with the fact that the trial court in another case had awarded money for a replacement car versus the fair market value of the vehicle that was lost. And so looking at that, what they're asking for is the market value of the vehicle that was lost, not a replacement car. And so that amount is what they requested from the defendant. And again, I think this is all theoretical in part because there was,
Yeah, I'd let you go past your time. I will give you your 4 minutes, but I did let you go past.
okay, thank you, Your Honor.
I was interested in your argument. I wasn't paying attention to the time as much as I should have been. And I'll give you an extra 40 seconds as well, since I'm giving her an extra 40. Whenever you're ready.
Morning, Your Honor. Police the court, represent Faith Dunn. I think the decision of the trial court, while there was some verbiage from the trial court of why the court did what it did, it eventually reached the correct decision simply because the city victim failed to meet their burden to prove the value of the economic loss as a result of the actions.
Well,
of the defendant.
didn't the defendant waive the right to a restitution hearing? I mean, isn't that the
Never-
problem?
in
Like,
reading-
maybe they didn't stipulate to the amount, but they said, hey, we're going to forego a restitution hearing?
I think the words of counsel more in recognition that potentially there was some restitution owed. But we never got to discussing that because the court said that they weren't going to order restitution.
Well, is that true? Like, in the order of the hearing, wasn't it at the beginning where the defense attorney basically said, we just want to go forward with sentencing and we're willing to pay the $6,100?
Well, I can't recall all the remarks that defense counsel made, but it appeared to me that he wasn't being,
I mean, he could have asked for a hearing.
he could have asked for a hearing, and in my mind, he should have asked for a hearing, because the evidence that was produced, first of all, what the victim was asking for was the fair market value of the vehicle. Well, you only get the fair market value of the vehicle as if it's a total loss. I mean, if I go out and break a window of a car on the street here, I'm not responsible for the total value of the car. I'm responsible for the damage I did. And there was never established that this vehicle was in fact a total loss. In fact, in the reply brief, they say, hey, we never recovered the vehicle. Now, I presume that's probably because she lives in Vegas and just didn't take action to do that. But without knowing what the damage is to the vehicle, we don't know what the victim is entitled to, because they're entitled to the damage to the vehicle, and if it's a total, then it's the total value. Then you get into the problem of the value that they did submit, which is very general. The 6175 is actually from this Kelly Blue Book, but the actual range is private party range 4,953 to 7,396.
But they didn't really have the opportunity to present evidence. I mean, that is not
They said
evidence.
They have a victim impact, and they
But
have
that
this.
is not evidence.
Well-
No, it's not evidence, first of all. But there was no opportunity to present evidence because the defendant waived her right to the hearing.
I take issue with that because what's been briefed by the victim is, hey, we can request restitution by non-evidentiary means, essentially, in your mind.
Well, actually, I didn't say that either.
Well, because the victim's saying, hey, we can request it by victim impact statement, we can request it by documents, we don't necessarily have to submit what would be classically evidence. In terms of
That was
testimony.
certainly her argument, but
Right.
I did not say I agreed with that.
Well,
What I
okay.
said was it wasn't evidence.
So we're here because they've submitted this document, but they never submitted the foundational in terms of what the heck the damage was to the vehicle as a result of the criminal act. So we never really got there, and so I think, again, the trial court reached the correct result, but for reasons that they did not articulate correctly.
Do you
I mean,
think that Marcia's law creates a constitutional right to restitution?
There is language within the amendment that would suggest that.
So in
There
that
is-
circumstance, below, should the victim have asked for an evidentiary hearing when the defendant theoretically waived its right to a restitution hearing? It seems like they both have a right.
That's potential. I mean, the court is the one that eventually has to ascertain what's the right amount, okay? And so the court has a duty to make sure that whatever they're awarding is supported by facts as opposed to just wanton desire. And so for that reason, I think the court should have a hearing where there's any sort of dispute. I mean, I don't know that it was conceded that 6175 was the correct number. I think counsel conceded that that's what the victim was asking for.
I think the counsel conceded that the defendant was willing to pay it, which is very close to almost a stipulation of value.
Well, I didn't see it that way. I think the representation was that the victim was willing, the defendant was willing to make restitution in general, not to a specific amount. I mean, look, the car was in fact damaged. There's some amount of restitution that would be appropriate. What that was, I don't know, because there wasn't any factual material submitted to the trial court which would allow you to determine that. Because even the 6175, we have no idea of comparison in terms of this vehicle versus the value of the vehicle. There is no mileage anywhere within the record. The title for the vehicle was submitted, but there's not even and the vehicle was purchased about 4 or 5 months prior to the criminal incident.
Do we know the purchase price?
No, It's not on the title. The mileage is not on the title because the vehicle's more than 20 years old, so that's an exemption under Nevada law, so they don't have to put the mileage on it. Additionally, there's boxes for whether the mileage is accurate or shouldn't be relied on or elect. All of that is blank. So I don't know what was. And interestingly enough, the purchase price to me would be potential evidence of what the value of this vehicle, since the purchase was presumably between a willing seller and a willing buyer. It was 4 months prior to the criminal incident. So that would have some bearing on what the value was, but that was not provided to the trial court. And clearly the victim knew whatever that was. There was insurance on it. It's reflected in the victim impact statement. She said she didn't want to submit a claim because she felt that her insurance rates would go up, even though that's contrary to Nevada law with respect to their administrative code. Section 687B 850 says you can't raise insurance rates due to a comp claim. Additionally, also in the same victim impact statement, she says that she would like to use the money from restitution to repay her sister, which raises this third-party issue that's not been briefed, but the court has raised. So I don't know that the 6175 is actually anywhere in actuality the economic damage that was done to the vehicle, and that's what the trial court is required to set by the decisions of this particular court. And when you look at the evidentiary materials that were submitted here, they're almost identical to the evidentiary materials that were submitted in other cases that this court has said, hey, it's just not sufficient. So they certainly had the ability to request the court to say, hey, look, we want to submit other things and we want to submit more material, but this is what they had, this is what they submitted. And so for that reason, we don't believe they're entitled to a second bite at the apple. I don't have anything else unless the court has any more questions.
Thank you.
Thank you much.
Give me just 1 second, please. I need to reset your timer. Okay, you have 4 minutes.
Your Honors, what my colleague said was he could have and should have asked for a restitution hearing, but he didn't, and neither did the defendant. And for that reason, I think this court has to agree with the victim appellants that their right to restitution was absolutely violated.
Well, even if we agree that they have a right to restitution, it doesn't seem like on this record it's very clear what the value of the restitution should be. Do you agree?
Yes, I would agree that there seems to be I went back through the transcript, and it looks like the defendant's counsel specifically said they're looking for $6,100 and some change. I have that number somewhere, and then the defendant says, yes, I'm willing to pay restitution. She doesn't say an amount.
So
But-
it's not really that close to a stipulation. It's like we all know what they're saying it's worth, but we don't really know.
Your Honor, the victim's very specific in the amount that they asked for. It's listed in the victim impact statement, is my understanding. Again, nobody else disputed that amount. I think that's the whole crux of this issue. And going back to that entry, courts speak through their entry, and they blanket denied the victim restitution based on the fact that she had insurance. And there's nothing in the statute that allows a trial court to deny that.
We could agree that probably both sides here have kind of a right to a hearing on restitution and a right to restitution or a fair restitution in the case of the defendant. But in this circumstance, we don't have a record that actually proves up the value of the restitution for this 20-year-old, what was it? 20-year-old, what kind of car?
I don't have that in
I mean, it seems
the
like it must be a very valuable 20-year-old car.
Yeah, I don't know, Your Honor. I didn't question the value because neither did anybody at the trial court level. And so I don't think that dispute is before this court today. I think the only thing before this court today is whether the trial court can blanket deny a victim their constitutional right to restitution based on the fact that they had insurance. And I don't believe that there's anything that my colleague or anyone else has presented to this court that would support that declination of my client's rights. Lastly, I just wanted to note that the defendant appellee does argue indigency as a proper way to blanket deny restitution for the victims. I don't see anything in the record that supports that either, and several district courts have actually said that the indigency of a defendant cannot be considered when determining the amount of restitution post Marcy's Law, because that would supersede any conflicting laws.
Well, reading the transcript, it appeared that the trial court discounted the defendant's assertion that she could pay the restitution. Now, there wasn't an amount stated, but she said that she could, and then the trial court seemed to doubt that was true. Is that correct?
I don't know what the trial court was considering
I
when
mean,
saying that they.
that's what
I
it said
think-
in the transcript.
Yes, correct. The trial court says that she's concerned about where the money would come from. I believe defendant Appley suggests that she does have supportive family members that are willing to help her pay that. You know, the thing about a restitution award at the trial court level is that the court awards the amount, and whether that's disputed or not comes with that restitution hearing per the revised code section. But then the actual collection typically would come from the fact that the victim appellant can then go get a certificate of judgment, where they can attach that to, they can garnish wages, attach, you know, to tax returns, et cetera. So there are other ways for the victim appellants to be able to ultimately collect that money.
Okay, your time is up.
Thank you, Your Honors.
Thank you both for your arguments. This case has been submitted, now been submitted, and we will issue a timely decision. That concludes court today. Thank you and have a great day.
All right.